Okay. Change is the law of life, and those who look only to the past or present are certain to miss the future. A warm good afternoon to everyone. On the behalf of Department of Law, Prestige Institute of Management and Research Indore, I, Kshitij Rajput, the moderator for today's session, would like to welcome our esteemed guest, Mr. Ashit Kumar Srivastava, sir, respected principal ma'am, faculties, and all dear students. Today, as a panelist, we have our honorable guests, Assistant Professor Kamlesh Jain, sir, Assistant Professor Mr. Nakul Singh Chauhan, sir, and the member of the EML committee, Mr. Yash Pathak. It's my great honor to welcome our esteemed guest, Mr. Ashit Kumar Srivastava, sir. Sir has pursued his 3-year LLB course from University of Lucknow and obtained his LLM from Rajiv Gandhi National University of Law, Patiala, in specialization of constitutional law. Sir has completed his PhD in data protection law from National Law University, Odisha. Sir has worked as an assistant professor of law at National Law University, Odisha, and Amity Law School, Amity University, Lucknow. Sir has cleared national eligibility test in 2017. Sir has been teaching since his post-graduation with a heavy inclination towards philosophy. Sir has published in referred journals, international journals, and UGC-recognized journals. Sir has also participated in several national and international seminars on diverse topics such as human rights, freedom of expression, global constitutionalism, and challenges pertaining to water sharing in SAARC regions, data protection law, and others. Apart from academic writing, Sir is a frequent contributor to several newspapers pieces at The Statesman, The Pioneer, and The Deccan Herald. Area of specialization of Sir are constitutional law, data protection law, and administrative law. Currently, Sir is an assistant professor of law at Dharmashastra National Law University, Jabalpur. In today's session, Sir is going to enlighten us about growth of digital constitutionalism in India. If any one of you have any questions or doubts during the session, you can write it in the Q&A box. Now, I humbly request Sir to kindly take over the session. Thank you.
Yes, thank you so much, Kshitij, for such an elaborative introduction. Just one point of correction. I'm in the final stages of my PhD. It's not complete as of now. But I have no hatred in saying it will be finished by this year itself. Yes, so I have chosen this topic to speak upon the idea of growth of digital constitutionalism in India, and I find this topic very interesting because it's more of an idea of consciousness. Because when we talk about the idea of law, we normally talk about the idea of black letter law, that the law is this, we should follow that idea. But for me, the idea of law reflects an idea of consciousness. How much conscious you are and how much your law is reflecting the consciousness. Because data protection law in today's perspective is that perspective, that are we conscious enough to undertake the idea that, you know what, there are several ways on which your privacy can be infringed. Just take a small example, then we'll head on with the lecture. If you can see my screen right now, right, my screen is blurred, right? You cannot see that at the back of my screen. Hopefully, I'm hoping that, right? And if you can see Nakul Singh sir right now, and I can see the background of Nakul Singh sir, right? Now, the background of Nakul Singh sir will give me an insight about him, where he is right now, right? Now, see, right? So the idea is data protection law is that we tend to collect a lot of small metadata every time when we interact with individual, right? And on collecting by that metadata, I'm able to generalize this idea that, you know, this individual is that person. I know that person. Who is that person, right? So this idea of blurring the screen or even the idea of not sharing my information is an idea of ensuring that I'm hiding my personality. Why? Because I have as much control over my personality on my information as I have control over my car, right? Because I have the same kind of responsibility towards it, because I'm conscious towards my property rights. Let's take a small example to understand it more deeply, and let's go more jurisprudential upon this aspect. This whole idea of privacy, the information, and why digital constitutionalism is becoming a new phenomena in this growing world is because in 2017 we had this very particular judgment coming out, the judgment of K.S. Puttaswamy. I hope everyone knows about that, right? Feel free to interact with me in this session because I tend to answer questions in that way. So in 2017 we had this judgment coming out, the judgment of K.S. Puttaswamy 1. And so it's a landmark judgment, and I tell you why it's a landmark judgment. Because Supreme Court for the first time recognizes privacy as a part of fundamental right. That's one aspect. Supreme Court also recognizes 3 aspects of privacy in that judgment: mental privacy, privacy of body, and then the idea of informational privacy. Okay, so mental privacy is here, right? You cannot know what is happening in my brain. cannot do that. And as it's a very nicely elaborated in the case of Selvi versus State of Karnataka, 2010, a very famous judgment. Privacy of body, something which we tend to secure for ourselves. If I am inside my cabin, I am free to do whatever I want to do. You cannot come and just see what is happening. You have to knock first of all. Then comes the idea of informational privacy. Now, why is informational privacy very important? I give you just one example that how we can collect metadata about an individual just by interacting with them. And that metadata gives us insight as to how that individual is. Right? Now, I have to have a control over my information. In this digital era, a lot of information about me is on the website, on the internet. That by default is calling out me to do one thing, that this has to be a regulation on digital social media websites to ensure that I have enough control over them, that they're not sharing my information to someone else. And this idea of information brings in the idea of constitutionalism, right? So when we talk about the idea of constitutionalism in a very conventional sense, I mean the idea of resistance. We are resisting against the state. That's the whole idea of constitutionalism. We are resisting against the state, right? That's the classic example of what is constitutionalism. When I say digital constitutionalism, I really mean I'm trying to safeguard my information. And now I know the greatest threat against information is not coming from the state actor only. It is coming from a non-state actor. And who is this non-state actor? It could be Facebook, it could be Twitter, it could be WhatsApp, right? So all these non-state actors have the capacity of infringing my privacy. Not only infringing my privacy, reading into my habits, my behavior, right? Now I want to safeguard my information. Now I have to ensure a certain amount of regulation upon these bodies so that this information can be as a sort of a resistance. You know what? I have control over my information. You cannot use my information. You cannot share my information with a third party. Don't do that. Why? Because I have control over my information. So this idea of informational privacy, when it was recognized in case for Swami as a part of a fundamental right, it also tells us something that we require a certain amount of protection. And we know we cannot get protection from non-state actors. And when I say non-state actors, I really mean the social media websites, e-commerce websites, who are always there observing your behavior at a scroll of a mouse. And I really mean scroll of a mouse. Even if today you're visiting certain website, and we'll do the small test in our lectures right now. When you're visiting a particular website and then you're scrolling on the website, even the scrolling is monitored, right? So I just moved my mouse from Nakul sir to Sitich. Even the movement of mouse has been recorded. Now that recording of movements also a dark pattern to understand what is my inclination. All that reading of behavior will affect my dignity. Why? Because at the end of the day, the whole idea of dignity is that I'm able to make free choices for myself. So if in a physical space, I'm entering someone's office, and I say, you know what, I don't want to stay here, I'm going back. I can do that. Why? Because as a human being, I can make choices for myself. But as a digital being, when I have my information stored in all the platforms on the internet, and they're using my information to find out as to what kind of individual I am, then targeting me through that information and sending me advertisements every time. You know what? And if you're a frequent user of YouTube, Amazon, Google, or any other premium website, you must be knowing about that, right? You scroll through a book on Amazon, suddenly you realize you're getting advertisement on YouTube, you're getting an advertisement on Facebook, you're getting an advertisement on any other premium website. And the advertisement is saying only one thing: buy it, buy the thing. Why haven't you bought it? Just buy it right now, right? So this idea of inherently pushing you to, this is what we call as a nudge effect in behavioral economics. Basically, they're pushing you to buy something, right? Now, can you regard that can't you regard this as an infringement of your dignity, right? In physical space, I think I go and I push someone, take this, buy this thing. That will be a grave violence of his dignity. Right? Why? Because we are so happy to recognize the idea of physical dignity. You know, the individual has a dignity outside. We cannot harm the dignity because Article 31 says that. And if we do that, there are laws for that. If I push someone, it's a battery. I cannot do that. But this is happening to you digitally every day, every second. Now, even when we are talking right now. So, isn't this digital push a battery sort of thing? Isn't this infringing your digital dignity somewhere, right? And this idea pushes us to recognize more regulation on this platform, e-commerce website, to ensure that while they are collecting data, they're not doing in such a manner that they are going to impact our behavior, right? Because at the end of the day, what is digital dignity? What is the idea of dignity? We want to ensure as a very small space is left for us that we can decide for ourselves. We are the owner of our fate. Small space, not more than that, because we know there's so much things are working in the background, right? There's the idea of someone else someone else work, right? We get very small space to decide for, oh, should I go and buy the ice cream or not? Should I go and buy the ice cream or not? And suddenly I see advertisement, I should go and buy it. Oh, I'll go and buy it now. And that maneuvering of your small portions, then the question comes up, where do you have this idea of dignity? So at the end of the day, the race is to ensure that you are able to safeguard that. And now when you know the physical space is secured, at least we can say that theoretically, it's the race to secure the digital space, right? And this whole idea of rise of digital constitutionalism as a phenomenon, it is not only happening in India. South Asia as a whole is realizing this fact suddenly now. And you know what? We need to safeguard ourselves, right? Because most of the non-state actors who are manipulating our data, who are securing our data, who are storing our data are Western countries. So South Asia as a country together, and believe me, India has a data protection bill right now, which has been pending for the last couple of years. Hopefully, it will become a law this year or by the next year itself starting. It's not only a case with India. Pakistan also has a data protection bill. Bangladesh is also coming up with a bill. Sri Lanka also has a bill. So suddenly you're realizing this fact, the South Asian countries are realizing this fact, that it is time that we have to counter this idea of maneuvering of data, or this idea of accumulation of data by non-state actors who are mostly mostly Western countries. Okay, so moving forward, I'll put forward a few ideas for you guys to understand. Then we'll take few examples to go more deeper upon this study. Just give me 1 second. I want to share something with you, and I'll share my screen. Hopefully, my screen is visible to all of you. Right. Let me know if my screen is visible or not. Can you see my screen?
Yes, sir.
Very good. I'll move this portion from here to here. Right. So Ashit has been moved to this side, left side. I hope this diagram is visible to all of you. Can you see this diagram?
Yes, sir.
Yes, sir.
Very good. Very good. Now, this is a diagram which I made after the judgment came out, the judgment of P.S. Puttaswamy. And now I'll tell you why. Because our idea, our sense of digital constitutionalism is coming from a copied version of European GDPR, right? And for people who do not know what is GDPR, GDPR is General Data Protection Regulation. It is a regulation which came in 2016. It is for governing the idea of data protection in European Union. So any country which is a part of European Union has to have regulations in consonance with GDPR. You cannot say we don't want to have it. You have to have it because you're a part of European Union. And I one more perspective which I'm trying to emphasize upon in the starting of the lecture was that this whole idea of data protection reflects the idea of consciousness. Right? How conscious are you regarding your data privacy? That's a question to be asked. We'll pick up a few examples also throughout our lecture series to understand it more deeply. But right now, let's go into the detail of it. Okay? Can you see this diagram, everyone? Yeah. Right. And feel free to ask questions. I really want you guys to ask a lot of questions to me so that my knowledge can also increase and yours too. Right. So this is a diagram based on the judgment of P.S. Puttaswamy one, which I made. Right. So you can see human dignity there, right? Human dignity is the basis of all other fundamental rights which you normally have. If you see you're seeing human dignity there, you see that from human dignity, privacy is coming out, right? You also see from privacy, 3 aspects are coming out. And those are privacy of mind, bodily privacy, and informational privacy, right? Right. Can you see that? There's this privacy, bodily privacy, privacy of mind, informational privacy. To safeguard informational privacy, as I told you, to safeguard my information, I have to have a regulation. European Union has the ideal GDPR. What do we have? So we require to have a data protection law. Can you see this one? Right. Now, there's a basic normative flaw in Indian jurisprudence. We recognize privacy, we recognize privacy of mind, bodily privacy, informational privacy, but we are not recognizing data protection law as a part of human dignity. Okay. And I tell you why. There's a normative fallacy there. Why? Because they're saying that human dignity has privacy as an aspect, privacy has informational privacy as an aspect. And to safeguard informational privacy, we require data protection law. That's the logic which is going right now. But we are not regarding data protection law itself as a part of human dignity. Okay. Now, what is the problem with that? See, when you read the Constitution, basically, and Constitution is all about the idea of grundnorm, normative jurisprudence, which we normally call, right? Every norm is backed by a norm, which goes to the idea of grundnorm. Anyone who has read Wilson, who has attended even 3 classes of jurisprudence, he would be knowing that the idea of Constitution is a grundnorm. So grundnorm is here, and all other norms are just descending from it, right? We are saying that we do not recognize data protection law as a part of human dignity. That means we are ready to recognize data protection law in India as a statutory law, but not as a fundamental right. But our data protection law, our data protection bill, is heavily influenced by GDPR. Okay. So the current GDPR bill 2019, or even the older one 2018, they were heavily influenced by GDPR, right? Now, here I find a normative fallacy. Why do I find a normative fallacy? Because GDPR is based on the idea that they regard data protection law as a part of the fundamental rights. Okay. Are you able to understand me, right? We do not regard data protection law as a part of fundamental rights, right? We are not seeing data protection law as a part of human dignity. You cannot see a linkage here. Can you? There's no linkage between both, right? It's a aspect of an aspect, right? Data protection law is coming from informational privacy. Informational privacy is from privacy. Privacy is coming from human dignity. But there's no direct linkage between human dignity and data protection law. But our laws made in India, PDP Bill 2018-2019, they are heavily influenced by GDPR. And for GDPR, data protection law is a fundamental right. Right? Article 8 of European Charters of Fundamental Right, 2000, Article 8 quite clearly says regard data protection law as a part of the fundamental rights. Right? Now, what happens due to this? Because of this, we have a law, Data Protection Bill 2019. But our jurisprudence is quite the opposite. So we are saying the data protection law is not fundamental right, but we are applying the laws of GDPR through PDP bill, which are reflective of the same idea that you do what? The data protection is a fundamental right. Okay? So what happens due to this? If you can just see this photo. Just give me 1 second. If you can see this, right? Can you see this diagram, everyone? Right?
Yes,
It is reverse engineering of digital constitutionalism. Now, if anyone can explain this diagram to me, I'll be more than happy to reward you some way or the other. Apart from Sitij, by the way, if anyone can explain this diagram to me and what I'm trying to hint towards, I'll be more than happy to reward you guys. Come on, give it a try. I just told you, right? Oh, I think the students had the exams well, right? So that might be one of the reasons. Right. So normally, how do you go about a swing? You come from the upper side of the swing, right, and you go down. Right. So that idea of going from upper part of the swing to the lower part of the swing is the idea of when you recognize the idea of data protection law as a part of human dignity. But we have not done that. But we are copying a law which has done that. So by default, when we'll apply personal data protection bill, we will be copying the GDPR, right? And GDPR is reflecting the idea of data protection law as a fundamental right. So we are reverse engineering the process and going upwards by copying them, right? That's the idea of reverse engineering of digital constitutionalism here, right? I'll come back to this diagram and more, right? But let's go more deeper to this study. I'll stop sharing it. Let's go more deeper into this study, and let's do some exercises to understand this phenomena more. You have to keep certain things in mind that human beings, as a natural being, are heuristic in nature. Okay? And when I say heuristic, I really mean that we are lazy in nature. Okay? And I'll prove you to that. Okay? Can you guys do me a favor, and everyone who's as a participant right now, can we visit certain websites and try finding the answer to us? Okay. Can you guys Google the idea of the best shoes in Indore? Can you Google this? The best shoes in Indore. Can you guys Google the best shoes in Indore? Everyone, it's exercise to everyone. Yeah. Yeah. I agree with you. I agree. Yes. Let's do this exercise and then have a question answer round also. I'm really more than happy to that. Okay. Google this, everyone. The best shoes in Indore, or where to find the best shoes in Indore. Just do that. Okay. Done, Katish?
Yes, sir.
Okay. Can you tell me?
Reebok and other shoe shops.
Okay, at the shoe shop. And can you tell me any shoe, any particular firm name or company name where I can buy the shoes in Indore as per your result?
Pantaloons, Red Chief.
Okay. And these are the stores in Indore, right?
In Indore, yes.
Very good. Anyone else who can give me a reply apart from Sidharth? Come on, you all use Google. Everyone use Google.
Yes,
Yeah,
I
please.
can also see that King Shoes Red Chief Indore Mahatma Gandhi store.
Very good.
Shoe yard. Yes.
And these are all in Indore, right?
Yes, sir.
Very good. Very nice. Thank you so much for helping me out to buy more shoes. Now that's one idea. Okay. Now I want to ask something to you guys. When you did this search for me and being kind and doing the search for me, how many of you went to page number 3 of Google search? It's a question to all of you. How many of you went to page number 3 to find the best shoe company for me in Google search? Come on.
To page 2, sir.
Okay, Sitish done a lot of hard work. He went to page number 2.
Anyone who went clicking more places?
Oh, nice. No. When you click more spaces, that's still page number 1.
Okay.
Yeah. Yes. Did anyone go to page number 3? Yes.
No, sir.
Okay. Okay. Anyone from the people who are participating in this discussion? No, sir. Okay. Yes, sir. Please no. Anyone went to page number 4? Page number 5, 6, 7, 8, 9. Hey, someone went to page number 9. Thank you so much. I got one guy who went to page number 9. Page number 5, 6, 7, 8. Okay, one went to 9. Very good. Thanks. What does it tell us about you? Now, I want you guys to observe this as a behavior for yourself. Right? Can I say that you guys trust Google a lot?
Yeah.
You were satisfied with the first? Yes, I'm very happy with the first result. That's it. No more research, right? Good. Can I also say that you're lazy?
Might be possible.
Might be possible. Yes. This is what we call as the idea of heuristic. Heuristic means the idea that human beings inherently are lazy. They do not want to do a lot of research, and they want to jump to the conclusion. It's a behavioral thing. You cannot deny this fact. We are behaviorally, neurologically made like that. We tend to be lazy, right? And we want to put conclusion. And that's why you see this lot of wars are happening all across the globe, because we do not do research. We do not read about other people's prejudice. We just want to come to a conclusion, right? Because that's the human nature. What I'm trying to hint towards is the first thing is that you trust Google a lot. That's not a problem. Very good. But what I'm trying to hint towards is that, is there a possibility that if Google wanted to divert you to a particular direction, you will be directed to a particular direction? Is there a possibility?
Yes, sir. There is a possibility.
Am I audible to all of you? I think as said, my voice is cracking. Is my voice cracking? Is this okay?
No, sir. It's okay.
Right. So this trust on Google. I'm not saying that trusting Google is bad. No, you can do it. Why? Because we are all lazy. But the problem is, there is a possibility that Google might direct you to a particular direction, right? And this effect is called as search engine manipulation effect. What happened to you right now is known as search engine manipulation effect. There's a very good paper written by Robert Epstein upon this idea of what is search engine manipulation effect. It's not true that it will happen every case. Even Google denies this, the research done by Robert Epstein. But this just shows that there is a possibility that we might be directed to a particular direction. And there's thousands of cases filed against Google by competition laws because they feel they are directing audience or customers basically to a particular direction. And if you remember 2016 US elections, right? A lot of people were saying that, you know what, the good things about Donald Trump were on page number 1. The bad thing about Donald Trump was page number 9, which only 1% went. Right? And the problem is only 1% went to, and he saw the bad stuff. He voted against him. But what about other people? This also tells us something more. We have a ranking bias. We have a ranking bias, right? Because as an Indian parent, we are teaching our students, our children about this, the ranking thing. You have to be number one every time, right? No number two, number three. You have to be number one. So inherently and psychologically, we have a ranking bias. So whenever we see first thing in a first search, we believe that. It is first. It has to be good. It cannot be bad, right? आपका बेटा क्या है? First time. That's it. So that's the whole idea, right? So what are the corporations doing? What are the corporations doing? I can tell you, they are manipulating your information. Nothing more than that. Right? Now, in this scenario, when they know about your behavior, when they know that you're going to react like that, how much dignity do you feel you have? Now, that's the whole idea of digital constitutionalism. Digital constitutionalism in India, we already had the Information Technology Act 2000. We know that act was there basically to regulate the idea of e-commerce, but or e-transactions. But that act was never satisfied or was not qualified to deal with this idea of data protection law. In 2017, 2016, when we saw this Trump election in 2016, and after 2017, when we recognized right to privacy, we came to the realization that we need to do something more, right? So we need to have a new law, because prior to this personal data protection bill 2019, we had this SPDI rule 2011. And SPDI rule 2011 in its true form is not helping us out to deal with e-commerce websites who are ready to scroll and collect your data. I can tell you some certain website today right now who are looking into information right now. But the problem is I cannot use the name because it's YouTube Live. So I'm stopping myself. But if you visit any premium e-commerce website in India, and do that after this lecture, do that. You visit any e-commerce website in India, working in India, and you go to the privacy policy, they quite clearly say by visiting their website, you have given their consent that they can share your information with a third individual. Right? Do you think that's very helpful to your dignity? If I visit someone's house and he says, you know what, I'm going to tell everything about you to my neighbor, how will you feel? Huh? You say, he's stupid or what? How can you do that? Right? Because you're so much alert with this idea of physical dignity. You know what dignity is? What? I'm physically alive. I'm physically this. I have a physical dignity. But you are not, because we are so ignorant about these small things. If someone tomorrow visits a particular premium store tomorrow to buy jeans, assume Siddish visits a very premium store in Indore and he goes and buys jeans. And the person selling the jeans tells him, you know what, sir, can you also give me your number? I'll send you more details about discounts which are coming in near future. You say, okay, why not? Not an issue. Please take my number. This was very happy. I'll go to discount. Very good. Suddenly, a political party person goes to that store and says the salesman, can you give me all the list of all the numbers of people who have bought clothes here? He says, why would I give you that? Oh, you only want $8,000. Give it to me. Now, why I'm telling you this? Once he gets your number, and now it's not a hypothetical situation. These things are happening during election days. Once he gets your number, and once he gets an idea of your bills and transactions which took place in the store, he would be knowing, he'll get an insight about your buying habits. Buying habits will give an insight about your purchasing capacity. What state of society you comes in, right? If I have bought a $5,000 jeans, that definitely says something about me, right? But you know what? This guy comes from upper middle class, not middle class, upper middle class, right? And then the individual knows what kind of ads or what kind of advertisement I need to send him through a WhatsApp. WhatsApp was utilized during the election period for this particular purpose, and we all know that about that. We cannot deny this fact, right? Right. So we need to ensure that there is a certain amount of regulation. I think the new IT rules which have just come out, it is trying to bring a lot of impediments on working of WhatsApp, or a lot of regulation of working of WhatsApp. It's not that a bad law, right? So we need to analyze this idea of informational privacy from a very practical perspective, because we're realizing this fact. The more we have been ignorant for so many decades, our information has been utilized against us. And once you get time after this lecture, just do this thing. Go visit any e-commerce website today, which is working in India, and see the privacy policy. It's mostly 2 pages. Mostly 2 pages. If you visit any e-commerce website functioning in Western countries, their privacy policies of 18 pages. Why is that difference? Because we never cared. They cared, right? Now, this caring and non-caring is creating a big debate. If you remember in February 2021, this idea came out. WhatsApp said, you know what, we're gonna change our privacy policy. Any information which is there, we probably might be sharing with our parent company, was Facebook. Right? Do you remember that, right? WhatsApp has a different privacy policy for Western countries also, right? A lack of personal data protection bill or lack of a data protection authority to be specific is allowing us to be pushed by a lot of corporations. So we need to ensure what kind of bargaining power today Kshitij, Ashit, or Yash has. Because the moment I visit any social media website, all I get as a bargaining power is I agree. And I click upon that and I enter the website. So what kind of bargaining power have? And to have that bargaining power, I require to have a sound data protection law today. I'll put this to Bill here right now. I want to interact now. I want questions to be there so we can have more interaction with students and people who are here. Yes.
So there's one question from Himanshu.
Okay.
So, but the IT rules are breaching the hierarchy of the law systems. The government is more supreme on taking the final calls.
Okay. Himanshu, in which context are you talking about? Because IT rules 2021, which we have right now, it has two aspects to it. Okay, first aspect deals with social media and the idea of messaging application. If you read rule 3, 4, 6, 7 till 7, basically, after rule 8 till rule number 14, they're dealing with the idea of digital news platforms or online content curators, right? So, in which aspect you're trying to talk this question? Can you ask me? Can you ask this question to me? I'll be more than happy to answer.
Himanshu, if you want to ask personally, you can raise hand and we can unmute.
Yes, please.
IT rules 2021.
No, I agree with you. But I'm saying the IT rules 2021 has two aspects to it. Rule number 1 to 7 are dealing with social media and WhatsApp, or basically messaging application. Okay, that's one aspect. The second aspect from rule number 8 to rule number 14, they're dealing with the online media content and online content which are there basically on Netflix or Prime Video or something like that. Of both social media. Okay, social media. See, I had written a paper about this idea of IT rules in that aspect only, and I wrote that I did not find that there anything which is unreasonable per se. If you read rule 3 of the IT rules 2021, and if you read all the conditions put in there, you know that any content which is infringing the sovereignty, integrity, or public order, or anything which is pedophilic in nature or which is obscene in nature, those content cannot be posted on social media, or if it is posted, any individual who's on the website on the social media can easily complain about that. I didn't find the rule 3 basically to be very unreasonable per se. Right. One of the arguments put forward by a lot of people who have been to the high courts at the various level, at Delhi High Court, Bombay High Court, Madras High Court, they have challenged rule 3 of IT rules on this very ground, saying that it is very nebulous. Nebulous means it is very vague. But when I analyze all the rules, if you have read Article 19 clause 2 of Indian Constitution, and if you compare rule 3 of that, you will find a lot of restrictions which are there in rule 3 are also there in Article 19 clause 2. So you can say they are stimulating the idea of reasonable restriction, not on a physical space, but on a digital space, right? So I'll suggest you to read rule 3 carefully once, and probably you'll get an answer there also. Himanshu, I hope I have answered you.
If anyone of you have any other questions, you can ask in the chat box, or there's also Q&A box, so you can ask there, or raise your hands so we can unmute you and we can directly ask to sir.
Yes.
So meanwhile, I have one question. There were some policies that were to be put on Facebook, Twitter, and WhatsApp, and I think they have currently not accepted the policies. So what is the current status for the banning of these websites in India?
See, we're talking about that April and May period when this idea was going on that Facebook will be closed by tomorrow. It will be closed by tomorrow, right?
Yeah.
Because as per the IT rules, now all the operations who are functioning in India and they're basically being utilized for sharing information, they're bound to submit a compliance report every month. We received this much grievances, and we have complied this much, and we are submitting this report to you. Right? That's the whole idea. And initially, lot of people showed a lot of resistance, and they were not ready to accept this idea. You know what, we won't comply with ID rules, and ID rules are creating a chilling effect, which was called out there. You know what, ID rules are creating a chilling effect. That's why we won't comply with this idea, and they challenged it. In Delhi High Court and Madras High Court took the lead in this idea. Bombay High Court also did the same thing. But for most of the surprise, a lot of corporations have complied now. So not only Facebook has filed, even Google has started filing compliance reports. So a lot of reports are filing. And the great thing about the IT rules was they gave a buffer period that, you know what, you should take this much time period of 6 months. I think they started in February. I'm forgetting the time period.
25th, I think 25th February.
Yeah,
2021 was started.
Yeah. And they gave a time period that you have to comply within 6 months or something like that. I'm forgetting the time period.
May 2021 till May, they had to accept policies.
Okay. So a lot of corporations now, they're suddenly accepting this idea itself. Regarding few messaging application or any other ones, their cases are still pending in high courts, and one petition was filed in Supreme Court of India. The Supreme Court of India has said that we're going to comply all the petitions together and going to hear it together. So this becomes a cumulative thing which has to be dealt with Supreme Court of India. So we're still waiting for their response to this. So it's a still a little tentative issue. Right.
Thank you so much, sir. There is one question from Bhumi Mishra. Is Pegasus spyware important or a threat?
Right. Wait, it is Bhumi Mishra. I cannot see the question.
It's in the Q&A box, sir.
Q&A box. Okay. I can see this question by sir. Please, can you explain the safe harbor protection clause they mentioned in your ID rules? Is it after this or?
No, sir. It's in the Q&A box. The chat box or other questions.
Okay.
And the Q&A box.
Okay.
Yes.
You asked me about the spareware, right? See, because the case is still pending, and the court has given the direction for forming of a specialized committee to handle this issue. I'm immuning myself to answer something upon that right now. Till the far the information, the true information doesn't come out as to really that spyware was utilized, we cannot comment upon that. Spywares particularly are not valid per se. We already have section 43 of ITR dealing with that. So for me to say that what was the current information, I cannot say that right now. So let's wait for the committee to come to a conclusion to respond upon that. We can have another session upon that someday when we get the current information throughout.
Surely, sir. There's another question from Himanshu that please can you explain the safe harbor protection clause?
I think it's a very good question which you have put forward, Himanshu. See, so to understand the safe harbor clause, you need to understand two aspects to it. Again, two aspects. Sorry for that, but yes, the original. Now, when you read this intermediary guidelines, right, the 2021, which is IT rules, which you normally call, and this is the idea of digital media ethics code, which we are seeing in 2021 rules. The original intermediary rules came in 2011. Okay, so this is not the first time it is coming in. So in 2011, we had the intermediate guidelines, 2011. The great thing about that 2011 guidelines was that it was directory in nature. So it was directing everyone listen, every social media website or any other platform which was storing information or sharing information, or was it relies for hosting information or exchanging information. It was directing every social media website to ensure that they follow due diligence. And what does the due diligence mean? That you need to ensure that any content posted on your website is not such a content which is derogating to the sovereignty integrity of India. It is obscene in nature, it is pedophilic in nature, or content like that, right? Now, what they said, you should follow due diligence. Now, this is the IT rules 2011, and if you read IT rules 2011 carefully, they had invoked section 79 along with 87 for creating IT rules 2011. Keep that in mind. These sections are very important. Section 79 is the section dealing with the idea of safe harbor clause, basically. So the IT rules 2011 invoked the idea of section 79 along with 87 to create IT rules. IT rules 2011 quite clearly says you should practice due diligence on your platforms. You need to ensure any kind of information posted on your website or exchanged in your website is the information which is not harming the integrity, sovereignty of India, is not obscene, is not pedophilic, and you got the idea basically. So that's 2011, right? What has changed? Because in 2011, when we already had intermediate guidelines in 2011, then why do we need to have 2021 IT rules? Because if that had done properly, this wouldn't be required, right? In 10 years, misinformation, disinformation has only increased, right? Right? The amount of pornographic content which was there has only increased. You cannot deny this fact. Right? A lot of these websites, or a lot of these messaging applications are utilized for sharing these kinds of information. You cannot deny that fact also. So the original intent of Intermediary Guidelines 2011, made under Section 79-87, was to ensure that social media websites or any other particular website storing information shall follow the idea of due diligence. But even after doing this, no change was coming in. And for the last 10 years, we're seeing this idea, this misinformation has only spread. The amount of misinformation you scroll every day is too much. Like, that's too much information for your brain also. Right? Now what to do? Right? Because you're realizing that due diligence is not working. Now you have to ensure something more. And what is something more? You have to fix liability upon the platforms to ensure that they remove the information ASAP. Right? That's the only way possible, because Facebook itself has around 1.9 billion users. Okay. Can you repeat after me? 1.9 billion users. That's more than a government body. Right? So if tomorrow a government department does something bad, I can file an IRTI, I can go against the government department, I can make it accountable, right? But for that, I have to catch them also. So I know that very less people work in government department, I can easily catch our individual, he's doing that. But with 1.9 billion users on Facebook, is it possible for government to keep a check upon every account? Is it? Right? That means you have to share the responsibility of ensuring the content posted on the website is regulated. Now the government knows it cannot do it alone, because the website is so big, it's like an ocean, I cannot control it. So we require people also, people at masses. If they see a content on the website which is against the IT rules, we can complain about it, right? Under Rule 4.2, right? Right? That's one aspect. Apart from that, if the company itself comes to know that any content posted on its website is infringing IT rules, it's their responsibility to remove that content within a particular time span. If they do not do it, the liability will be their own. Right? Thus, you're bringing accountability by removing the safe harbor clause. So if you read the new IT rules 2021 and do this, just compare the preamble of IT rules 2011 with the preamble of IT rules 2021, and you will see something very common. IT rules 2011 was invoking section 79 along with 87, but the new IT rules 2021 is only invoking section 87. Why? Because it has removed the safe harbor clause basically. Right? And if you read Rule 7 of the new IT rules 2021, Rule 7 quite clearly says if content is not removed by the platform within a reasonable time, or the time has been given there, then the liability of that content posted will go upon the platform itself. Now that creates an incentive, a negative incentive against the platform to be more attentive and to ensure that they're exercising their due diligence properly now. Is this clear? Is this clear to Himanshu? I think Himanshu raised this question. Hopefully.
I think it's clear, sir.
Yes.
There's a question in Q&A box from Rachit Pandey. Recently, Hyderabad police searched individuals' WhatsApp chat whether they have used the word marijuana. What is the extent that authorities can look into one's privacy, like checking one's WhatsApp? Is it infringement of personal privacy?
This is a very good question. It's a question which has been raised time and again by few of my colleagues also who are practicing actually, and they want to know this answer. If I go by a very technical, very legally, now IT rules are part of a legal jurisprudence, right? If we have to go by that. If I read Rule 4.2 of the IT rules specifically, and if you read and do read it, Rule 4.2 quite clearly says that any messaging application which is utilized for sharing information, and you know what we are trying to hint towards, right? Any messaging application which is utilized for sharing information and which is using end-to-end encryption, and now you definitely know what they're hinting towards. Right? Any messaging application using end-to-end encryption for sharing information, and if there is a suspicious that the information shared is violative of the sovereignty integrity of India, or is a violation of any other law in India, or the idea of public order, the competent authority. Now, who's the competent authority? It can be any authority which has been assigned by the court of law. And I'm giving an order, I'm assigning this to an individual, or any other authority as per Rule 69 of Rule number 9. I'm so sorry. There's one more rule in Rule 4.2. I'm forgetting the rule. I'll share the information with you when I remember it again, right? So competent authorities are given power under Rule 4.2 to even check who is the originator of that message. And this is what we call as the originator of message, right? So under Rule 4.2, if that particular message is leading to the violation of the sovereignty, integrity of India, public order, or a violation of any law particularly, the Rule 4.2 does gives empower to the competent authority to ask as to who is the first originator of the message under Rule 4.2. But this one addition to is if you're reading Rule 4.2, there is a provision to Rule 4.2. Provision to Rule 4.2 quite clearly says if there is any other way possible to find out as to who is the originator of the message, then you do not need to check through electronic means. Okay. That means because you're taking WhatsApp as a proof, this guy sent this message to me, right? This cannot be done at the first instance. This has to be the last instance. First instance has to be you have to find out by other means possible. You know what? Who has shared the information? Who could have done? Oh, that information was shared in that area, so possibly this guy might have sent it, right? But you cannot just go and check someone's phone unless until you have an order by competent authority as per Rule 4.2 of this, right? This one more thing which I think I missed out was that there are specific rules to govern this idea of taking more messages. I'm forgetting the rules right now, but I'll surely share with you whoever has asked this question to you. Okay. So to the person who has asked this question, read Rule 4.2 of IT Rules 2021 and you'll get your answer from my side. That's the answer. Yes.
There's a question. Asus and Komal Saluja have raised their hands. I'm unmuting you, Asus, if you want to ask a question.
Okay.
Asus, kindly write your question in the Q&A box, so I'm not able to unmute you.
Asus is a computer application. His computer.
Yes, sir. I think the participant have forgot to change the name.
No, they're happy to attend digital constitutionalism. I'm happy with
that. Maintaining the privacy, sir.
Very good, very good. Oh, nice.
Meanwhile, sir, I also have one other question. I've read that UIDAI Aadhaar wants an exemption from the data protection law.
Yes.
So, what are your opinions on this, sir?
Right. So regarding UIDAI, this is a little off-track question. Off-track because the original UIDAI when it came in 2009, it was a notification basically, right? So that's the whole problem, right? That till so far, and even today when we're talking right now, we used to visit so many platforms. We used to visit CC. We used to visit so many places to just buy food, eat, drinks, right? You were sharing information like anything, right? We were so ill concerned because privacy is the least thing we are concerned about. We're concerned about employment and other aspect right now, and that has to be there. But we were very less concerned about the idea of privacy. It is only after 2018, 2017 when we got this bill coming into existence and this global phenomenon. When I say global phenomenon, I really mean it because many countries now in across the world are being inspired by GDPR. And if you read Pakistani data protection bill, a lot of provisions are copied from, or not copied, and inspired by the GDPR, right? Everything it's a global phenomenon. So people are getting cautious about their rights. I have a data protection rights. So when you ask this question, because we are not conscious about data protection law, the original UIDAI came in 2009. There was no act to govern the idea of privacy at that time. We had no privacy as a fundamental right, so we are not concerned about that. The Aadhaar Act came in 2016, right? And the Aadhaar Act quite clearly says that there has to be consent taken by the person who wants, and it's not mandatory per se. We all know that Aadhaar is not mandatory per se, but it has to be consent. But for 7 years, you gave your data. No,
yes,
without consent, because you did not know, right? So 2016 that's the problem, right? Our legal jurisprudence is so black, it is still growing, and we have done so many things like this only, and now we're like, oh God, we did a legal mistake. How to correct this retrospectively? If Sitish tells me something private about him today, and tomorrow privacy comes into existence as a law, Can Satish go? He says, you know what? Destroy that information from your head. Can I do that? And that's the problem with information. Information tends to stay with you, right? So even if the information was collected priorly, now the nature of information is sustainable. Okay, right? It's not like a cotton candy you eat and it's gone. Yeah, no, it's sustainable. So if I have information towards you or anyone else, that information stays with me a sustainable period. So having information for a longer period of time after privacy coming into existence, it can still be utilized for tracking me down, right? So that's why I said the idea of question of Aadhaar is a very if someone who has really read privacy, goes into privacy so much, he can never answer this question, because government will clearly say the idea of UIDI is not a necessity, because we really require to have one form of identification for all the citizens of India, which is a very legitimate demand. But getting this information from you for your Aadhaar also requires your consent. What happens to individuals who are registered prior to that? There has to be a little legal complexity has to be there. So there's no perfect answer to that. Yes.
There was a question from Yashvardhan Yadav earlier. He asked that we all talk about data protection, but we also know that the applications we use take permissions to have access on our device, and they use our data. For example, I searched for law courses on Google and visited the website Quora, and then after some time, I got a call from different college coaching regarding law. So that proves that someone, either Google or Quora, is sharing our data. So how can that there's a protection of data?
See, normally what I refer is, okay, let's be more practical, and let's go much more practical with our needs also, right? We all book airline tickets, right? We all do that, right? And we have all suffered the airline crisis, right? If you're on a normal website, and when I say normal website, I mean not in an incognito mode. You're a normal website basically, and you're browsing the internet and you're booking tickets on airlines. I think you might have seen this escalation of prices, like, ooh, in 5 minutes before you're booking, and then you're deciding should I go or not, should I go or not. 5 minutes, the prices increased, right? So this escalation of prices on airline, you must have seen that. If you're booking ticket incognito, you'll see that it's not happening at that rapid pace. It's still happening. The major problem with that is that you all, when you're accessing internet, you're using IP address. Internet addresses, it's given to all of you, right? You all have that. Every time you visit a particular website, and particular website has subscribed to a particular application of any major operation. I'm not naming them, right? Whenever you visit their websites or through their website, they attach a unique identifier to your IP address. Okay? And once they attach a unique identifier to your unique address, wherever you go, whatever you do, that information is being collected throughout. And now anyone who has paid money for the application as a business owner, you know what, I want to know about this much, collect that information, give it to me. Anyone who has paid money for that, he'll get that information. It's like going to a sari shop, and this is an example given by some professor I met 3 years ago. I'm forgetting his name. Good, so Dr. Sorish, I think. He gave a good example. He teaches AI. He gives an example. You go to a sari shop, and the sari wala says, "Ma'am, just tell me your preference. I'll show you all the list." Right? Or if the sari wala knows the woman, oh, you come take the sari. Why? Because the sari wala knows her so much. So this idea of unique identifier to your IP address, and then the collection of information for the individual, and then selling that information to the individual business owner, and then business owner calling that person up, oh, you know what, you want to have this course? I'll give you this discount. Don't worry. Right? And why did I undertone my voice? Because it's all very secretive. Right? It's all secret. This is what we call as dark pattern of social media or internet. It's a dark pattern. They're reading about you every time, every day, every second. They know about you. This is just one thing. Okay, what I personally feel, the only solution to this is once our data protection comes into existence, we will be having a data protection authority. The foreign data protection authorities who are working with GDPR, they are putting heavy finances upon Facebook, Google, or any other, even Zoom, just to ensure that there's privacy. that is creating a deterrent for them to work as the rule of law. For us, there is no such authority right now. Even if you're working in incognito mode, there's a possibility there are very unique identifiers who are still able to capture your incognito mode also. So if you're thinking that incognito mode is a safe mode, no, it's not. There's a possibility that they can capture you from that also, right? So I'm telling you, they are sophisticated tools to learn about your behavior, right? But till the time we do not have a authority to regulate them, deter them basically, they will not learn about this. I'm pretty sure about this because it's a market rule. Market rule. What is market rule? Survive. Survive. Yeah.
So I'll be unmuting Asus now.
Yeah.
You can unmute yourself, Asus, and ask the question.
Hello.
Yeah, you're audible.
Sir, actually, I want to ask a question regarding one of the recent case which I dealt in. The case was related with the violation of Instagram and YouTube policy, where a content creator has posted a series of shorts. Like he has taken 10 or 8 seconds mini clips from different videos or posts, and he has made a roasting video and has used many of the abuses word in that video. So the girl whose picture was taken in that video for a couple of seconds, and it was for at various instances, like for 5 seconds, for 1 second, and for 6 seconds. It was visible for more than one time. To me, I raised a complaint on Instagram Health Center regarding, and I drafted approximately an email for about 2.5 pages describing every aspect this is the defamation, like under which it is covered. And I even mentioned that as per the US laws, the defamation is also a criminal offense. I mentioned them the sections as well. I interpreted every word used in Hindi and gave the translation in English as well.
Yes.
I took the screenshot of their guidelines that no one can copy the content. The Instagram first guideline itself mentioned that you cannot copy anyone's content. All the guidelines, but actually, even after so much of drafting and asking them to remove the content violation, there was a mail which said that we did not find any of the violation of any guideline. Just a one-line mail they have sent. So in these cases, how to deal with such things? Because and another case was like one of my colleague who is also an advocate came to me and asked that his Facebook page was hacked and like adulterated services were being provided on his page. So he said that I want to discontinue this page, but I want to again want this page back and image also, and defamation case should also be filed. But as the hackers use VPN and jammers, we cannot trace them.
Right.
So, and we asked the Facebook for recovery. There is no response from their side because the function is totally broken. Facebook recovery function is totally broken. Another instance happened that a multinational company asked for the payment of 28 lakh rupees from my client. And in this discussion, an invoice was raised by the company in which they mentioned their bank account and all the details. But in the middle section, like I was sending, like you are a company, you send me mail from your registered email, like @soandsocompany.com. But in between, a hacker changed their address and was sent to me. Means my client, and I paid the amount, but company is saying that I haven't received any amount. So in such cases, how to deal with, because there are many, these cases are not covered under any act, because
actually SSG right.
Actually, sorry to interrupt. My name is Manish Ahuja. Actually, I am.
See, that's not a problem. See, you kept
sure.
I was very happy with that. You do not need to reveal your information. It's not a problem with me. See, what you're talking about is the idea of cybercrime, basically. And we are going to start a course also in our university upon the cyber crimes. There are a lot of cyber cells and police stations which are ready to take these cases. But the problem is that there's lack of awareness as to how to deal with these cases, basically. We talk about this issue basically of Instagram, that the individual was creating a cyber defamation. Cyber defamation is a recognized principle, but not every police station is very aware of this idea. Even they follow the old procedure. They'll send a notice to the Instagram, and Instagram says, "We know this is not a violation of our policies. We're not going to do that." As per the new IT rules, they're bound to do it for the grievances. And if they do not do it, the liability will go upon them. If you have a particular lawyer in your area which you're acquainted, or if you're a lawyer by yourself, I think you can easily access this information. And this is a punishable offense, cyber defamation. This is what we call a cyber bullying also now. So this is a punishable offense. So do not be demotivated by the reply of Facebook or Instagram. They will never do something because they do not take these issues very seriously. But these are criminal offenses. For that,
sir, that is the reason. But actually, the point was that girl, because of that video, actually the girl is a content creator and having a much followers on his channel, like everywhere on YouTube and even on the Instagram. But due to that recent video, she has disabled all her accounts.
Right.
The main cause, like if you will understand the societal cause, is that because of that video, she has disabled, she has permanently deleted her Instagram account on which she was getting ads by the brand, and her monthly income from that Instagram account was about 20 to 30,000 per month. She was having a YouTube channel having a subscriber of at least 1 to 2 lakhs, and there was a monetary income from the YouTube of about 20 to 30,000 per month. And he was also getting some ads and brand for the practical ads and brands, like shooting and all that. But this is not only a not only a monetary loss. This is also a mental loss. But Instagram service, like Facebook has recently opened a service center in Indore, like help center in Indore. But if you will see that the draft is in an automated format. Like whenever there are drafts are made that in under which category your case comes. Whether it is a cyber bullying, whether it is a harassment, whether it is the modesty of a woman is being disrobed, or whether your account is hacked, or whether there is a violation of content or the copyright violation, IPR violation. But all these things, even if we mention, the automated generate mail says, even after all these options, it says that we only handle the case if there is an IPR violation. Then why are you providing so much of long list in that thing?
It's a clear case of violation of the defamation. And as per the new ID rules, they are bound to recognize this. If they are not doing it, I'll still suggest to visit a police station near you and register this complaint with them.
Sir, I have registered a complaint. They are saying you go to cyber cell. Cyber cell has registered a complaint. They are saying that we cannot trace the hacker. We cannot, because that video has been now deleted by someone and it was posted from an ID which was on an internet cafe.
Right.
So, if you are not able to do this, then how will a person fight for his own right? Because ultimately, if we see the law of the land, if we see for the law of the land, if your right is violated, you are liable to be paid the compensation.
Right.
And if the offense is committed against you, the person committed the offense should be punished. This is the law. And if you are not able to provide any, because if we are seeing this route, it is going it is going parallelly. It is not going. Because if you are committing a crime, the person is being suffering from that. So they are going parallelly. But this should stop somewhere, because this is, I think the coming generation after 2025, everybody will perform most of their work on the internet.
Online only. Yes. There has to be more awareness at the police level also for this. And not only police level, there has to be a lot of help from the
and sir,
corporations.
I feel like very pity for the act that our IPC is containing about 500 sections. But our IT Act is containing only 100 to 120 sections. If we go for the Sydney Act, that is Australian Sydney Act, they are containing 700 sections for different offences on cyber.
Actually, we are very mono-provisional. We use one section of IT Act for everything almost. If you see,
even if we go for the interpretation of IT Act section from 60 to 67, which are really offences dealing sections, we have to make to understand the code that these are the offences which are having a very vast interpretation in their own language.
Yes.
But I don't want to defamate any judge or what, but they are not able to understand what actually the point the legislature has intended.
I totally agree with you that there's a lack of awareness for this, and that's why our university is also going up with a course upon this right now.
Sir, recently, Y.V. Chandrachud Saab has said in his judgment that India should now train their brains before enacting the laws and legislation, so that we should not copy any other's land law. We should make our own laws, because every country has a different parameters of their problem.
Yes.
Recently, I have thought for filing a PIL against this case, because there is there are many people who are having a valuable accounts on Facebook.
Yes.
But there is no support system for the recovery of account.
There's no safety also. There's no safety also. Yeah.
Like, I don't know how, and I personally think that until and unless there is a very like common problem with the Indians, that they do not totally understand the terms and conditions of license agreement at all.
Yes.
I think in one of the country I studied that they have mandatory made this provision that every person, when like there is a 15 rules and regulation, so you have to mandatorily take every section, like you have to click on that section. So by that, even if not 1%, 30%, not 100%, but 30% will read the terms and condition before signing on a paper.
No, so in foreign jurisprudence, actually, they have this idea of boilerplate agreements. Before you're signing anything, and if the boilerplate agreement is against you and it's unreasonable, the court will always go in favor of this idea of the individual who has suffered the loss. There is a lack of awareness regarding cyber securities, which we cannot deny this fact, are at a lot of levels, and we are trying our best at a legal education level, but we're trying to aware people of this. So this our research, this certificate course which will be running on cyber security. The aim is to do this the same thing, create awareness regarding cybersecurity, not only at a mutual level or at the executive level, for everyone who attends that particular certificate.
Recently, I have drafted a PIL regarding Facebook, like Meta. Now the Facebook is under the name of Meta. Now every WhatsApp, Facebook, Twitter, not Twitter, Instagram is under the brand name of Meta. So I have drafted an PIL, PIL regarding the thing that there should be a proper redressal forum.
Yes.
And the proper redressal forum doesn't mean only online platform, because although we understand that Facebook is running in US, but if you are worldwide, you are providing your services worldwide, your service center should also be worldwide.
No, so no, as per the new IT rules, they are required to have the grievance officer, redressal grievance officer as resident in India. So if you read all the rules, it is mandatory for them.
Sir,
the problem would be that he might be located in somewhere a very metropolitan city. So access to him might be a question which I am still ready to accept that idea.
Sir, there is a redressal officer in Indore as well, and that is to whom I reached, and I asked that the forms you are providing online are in a very system generated forms. Whenever we are taking any of the problem, the automated reply comes that we only deal with the IPR problem. Then why are you providing so and so options?
That's a very functional problem there.
So he said that we are provided with the job and we are doing that job. You can, if you want, you can case on us. Like, this is not a reply for such things.
They said that you can file a case upon him.
Yes, and if he will file the case, the company will say that he is fulfilling his job and he is not under such obligation to answer you for that thing. Like
yes, thank you so much, SSG, for bringing this, highlighting this point for my idea. I'll surely inculcate this for my certificate courses, that I can aware people about this.
Yeah, because actually it is not necessary to mention this, but many of my clients are crying for their accounts because they have provided like past 5 to 6 years for generating subscribers and followers. And they are not like providing any like vulgar videos or anything. They are providing informative content on their Instagram and YouTube profile. Like one of the friend who is teaching acting classes online. So this is not like something which is not entertainment. Like it is not a vague videos. They are providing informative videos. So they are crying for their account because they said that we are earning from this source only. Now we have to start from the square one again.
I totally agree with your perspective, and there is a lack of awareness. I think we should have to blame for that.
Any guidance if like what can be done, like if we are an advocate in PI, we can include any points which will be in our favor.
I think what you have done, you have already exhausted a lot of remedies which we normally suggest, right? If there is anything else which I can suggest you, I'll consult with my colleagues also. I'll reach out to you for that.
Thank you.
Thank you so much, Manish sir. Sir, with your permission, may move forward to vote of thanks.
Yes, please. Thank you.
Thank you so much, sir. Okay. Thank you, sir. Now I would be taking the session towards the end. Today, my words are not enough to express my sincere gratitude on the behalf of Department of Law, Prestige Institute of Management and Research, Indore. I, Kshitij Rajput, would like to express my sincere gratitude to Mr. Ashit Kumar Srivastava, sir, for sparing his valuable time and sharing so much knowledge about data protection law and growth of digital constitutionalism, especially the privacy laws, and giving us precious knowledge in abundance. I would like to thank our principal, Dr. Sunita Arya ma'am, for the support. I would like to thank Assistant Professor Mr. Kamlesh Jain sir for organizing today's EML session and for his support and guidance. I also thank Assistant Professor Navrati Dungre ma'am for her presence. A special thanks to Assistant Professor Nakul Singh Chauhan sir for his support throughout the session. Heartfelt thanks to student coordinators of the EML committee, Mr. Priyanshi Jain, Mr. Nishan Jain, and other committee members who have worked hard and made it a true success. And amongst all, I thank all the participants for their patiently listening and showing their interest in the EML session. Once again, thank you everyone who has assembled here. Thank you so much, sir, for your presence.
Thank you so much for inviting me, and I learned a lot, and I also got to know the practical aspect. I'll surely inculcate that, and I'll surely, if I come to with a solution, I will surely share the solution with the concerned person. Thank you so much for inviting me today. Thank you so much.
Thank you so much, sir. We would be really happy to have you with us on the campus.
Surely. Anytime, surely.
Maybe end the meeting, sir?
I'll leave. Thank you.
Okay. Thank you so much, sir.